The email arrived while I was grading papers in my tiny apartment. Notice of termination of tenancy. Vacate premises within 60 days. My home of 7 years was being pulled out from under me. I waited until the weekend, after submitting final grades for my community college English classes, before typing my response. I'll need clarification on the grounds for eviction. My name is Nora Wilson, and at 34, I just received the most callous eviction notice in history. But while Gordon Mercer was probably congratulating himself on his brilliantly executed real estate play, imagining me scrambling to find a new place in this impossible market, I was calmly researching tenant rights in our city. It all made sense now. The sudden property inspections that never happened in previous years, the way maintenance requests went unanswered, the realtor accidentally showing my unit to prospective buyers while I was teaching. 3 months ago, I'd overheard Gordon talking to someone outside my window about market rate potential and getting rid of legacy tenants. That same evening, I joined the local Tenants' Rights Association and started documenting everything. A week later, when the building's longtime manager Tessa had stopped by to casually ask if I had plans to move anytime soon, I'd smiled and said I loved my little place too much to leave. The rent-controlled apartment I'd been living in since graduate school was now worth nearly double what I paid, and Gordon had clearly grown tired of waiting for me to leave voluntarily. My phone dinged with an email response. The building requires extensive renovations that cannot be completed with tenants in residence, and this is a legal basis for termination under City Ordinance 47.3. I didn't respond to the email. Instead, I called Carmen, the housing attorney I'd consulted 2 months ago when I'd found a fake inspection notice citing violations that would require tenant removal on my door. "Forward me everything," she replied, "and keep documenting." Another email from Gordon. "I understand this must be difficult for you. The housing market is challenging, but surely after 7 years you might want a change of scenery. I can provide references for your next rental." My tiny apartment, with its worn hardwood floors and the window seat where I'd graded thousands of student essays, the place where I'd nursed my mother through her final illness, the home whose every inch I'd lovingly made my own despite not being allowed to paint or make permanent changes. I smiled, thinking of the recordings I had of Gordon telling prospective buyers how he planned to renovate and double the income from my unit once I was out. I spent that evening in my apartment, the apartment Gordon had inherited from his father and had been trying to push me out of for years. I found my original lease agreement, along with every rent increase notice, every maintenance request, every communication we'd had over 7 years. Another lucky instinct that had paid off. I'd kept digital and physical copies of everything since the day I sensed Gordon's resentment when he took over the building from his father 3 years ago. My phone kept dinging with emails from him, each one more condescending than the last. "I've consulted with my attorney, and the renovation necessity is entirely legal grounds for termination. I'm offering you a courtesy by providing 60 days when the law only requires 30. The market is what it is. You've benefited from below-market rent for years." I forwarded each message to Carmen, adding them to our evidence folder. The last email caught my attention. "By the way, I've already listed your unit for rent starting next month at the new rate. I'm confident the renovation clause will stand up to any challenge." "Perfect," I called Carmen. "Gordon just admitted in writing that he's already advertising my apartment. He also mentioned a renovation clause he knows won't hold up." "Forward it to me," Carmen said, "and check online rental listings. If we can find the actual listing before you've even moved out." I was already searching on my laptop. There it was, my apartment, my view, my window seat, listed at nearly double my rent, available immediately after minor updates, with no major renovations planned. I took screenshots of everything, my hands steady as I documented Gordon's lies. My phone dinged again. "Don't worry about your security deposit. I'll be reasonable about normal wear and tear." I actually laughed out loud at that one. Did he really think I was worried about a security deposit when he was illegally trying to evict me? Had his greed grown so large that he'd forgotten how tenant protection laws applied to his precious investment property? Another ding. "I know this place has sentimental value to you, but business is business. You're an educated woman. You understand how real estate works." I poured a glass of wine, the good stuff I'd been saving for the end of the semester. This qualified. Tomorrow, Gordon would learn some hard truths about tenant protection laws and rent control ordinances. But tonight, I'd enjoy the quiet and plan my next chapter. Morning brought a flurry of increasingly urgent emails from Gordon. My contractor needs to measure the unit tomorrow. Please confirm a time you'll be available. Did you receive my previous message about the contractor? I need your confirmation about move-out logistics by end of day. I silenced my notifications and headed to campus. Friday was always my busiest teaching day, and I had a stack of creative writing assignments to return. Life goes on even when someone is trying to illegally evict you. Around noon, my phone rang. Gordon's first actual call since sending the notice. I let it go to voicemail. The message was predictably patronizing. Nora, I understand you're probably upset, but I need you to be reasonable here. My contractor has a tight schedule, and we need to get measurements done. Call me back to arrange a time. I put my phone on speaker while organizing my lecture notes. Did he mention measuring for renovations in his messages? The ones where he's already advertised my apartment with no major renovations planned? Carmen was going to love this recording. By late afternoon, Gordon had escalated to threats. If you don't cooperate with the renovation assessment, I'll be forced to deduct costs from your security deposit and potentially pursue additional damages. I forwarded each message to Carmen, letting her track Gordon's mounting legal missteps. Through the grapevine of longtime tenants in the building, I'd learned that 2 other rent-controlled units had received similar notices. Both tenants, an elderly man who'd lived there for 20 years and a single mother with 2 children, had already started packing, believing Gordon's claims about the legality of the evictions. My neighbor, Lucia, knocked on my door that evening. Are you really fighting this? Gordon says we don't have a choice. The building needs work that can only be done in empty units. I invited her in and showed her the listing I'd found online. He's already advertising my apartment for rent at double the price, with no major renovations planned. He's lying to all of us. Lucia's eyes widened as she scrolled through the listing. But I can't afford to fight him. I can barely afford to move, but what choice do I have? You have the choice to stay and fight an illegal eviction, I said gently. I've connected with a housing attorney. Would you be willing to talk to her too? That night, I hosted an impromptu tenant meeting in my apartment. 6 of us, all facing eviction notices with various timeframes, shared what we knew. I showed them Gordon's contradictory messages and the online listing. Carmen joined by video call, explaining our rights under local rent control laws. What he's doing is textbook bad faith eviction, she explained. Claiming renovations when he has no permits filed, already advertising units at higher rates, pressuring tenants to leave before the notice period ends. We have enough for a solid case. Mr. Ramos, who'd lived in his apartment for 20 years, looked relieved and terrified simultaneously. But I already told my daughter I would move in with her next month. I've started packing. You don't have to move, Carmen assured him. And if you join our case, we might be able to get compensation for the distress this has caused. My phone dinged with another email from Gordon. I understand there was a gathering at your apartment tonight. Please remember that tenant meetings require advance permission under building rules. I smiled, adding it to our evidence file. Intimidating tenants for organizing was another violation to add to our growing list. The following Monday, Gordon escalated his approach. I returned from teaching to find a formal-looking notice taped to my door. Final warning, access required for contractor assessment. Failure to comply will result in legal action. I photographed the notice, then calmly removed it and went inside. Carmen had advised me not to engage directly with Gordon anymore. All communication should go through her now that we were preparing our case. That afternoon, I heard a key in my lock. I was sitting at my desk grading papers when my door swung open, revealing Gordon and a man carrying a toolbox. Oh! Gordon looked genuinely surprised to find me home. We, left notice about the contractor visit. I didn't get up from my desk. You did not schedule this visit with me, and you did not give proper notice for entry. You are trespassing right now. The contractor looked uncomfortable. Gordon straightened his shoulders. This is my property, and I have the right to enter for assessment purposes. Not without proper notice, you don't, I replied. already recording the interaction on my phone. Please leave immediately and follow proper procedures if you need access. Gordon's face darkened. This attitude is exactly why. He caught himself, but not before I'd captured his near admission on recording. Why what, Gordon? Why you're trying to illegally evict rent-controlled tenants? Why you're advertising my apartment online before I've even moved out? Please finish that thought. The contractor was already backing toward the door. Man, you didn't tell me this was an occupied unit with a dispute. I don't want any part of this. After they left, I sent the recording to Carmen, my hands finally shaking slightly with the adrenaline of the confrontation. This was no longer just about keeping my home. Gordon's actions were becoming increasingly hostile and desperate. Carmen called immediately after receiving the recording. This is perfect. Illegal entry, attempted intimidation, and he almost admitted his real motives. I'm filing for an emergency injunction tomorrow to stop all eviction proceedings. Can you gather the other tenants for a meeting with me? That evening, 9 tenants crowded into my small apartment. Carmen explained the class action suit we were building and the immediate injunction to halt all evictions in the building. Based on the evidence Nora has collected and what I've heard from all of you, we have a strong case for bad faith evictions, tenant harassment, and violation of rent control ordinances. The penalties could be substantial. Lucia raised her hand hesitantly. What happens if we lose? He'll just make our lives miserable and evict us anyway. Carmen shook her head. If we prove bad faith, which we have solid evidence for, the court can bar him from evicting any of you for a specified period, often years. He'll also face significant financial penalties, possibly including damages paid to each of you. The mood in the room shifted from fearful to cautiously hopeful. Mr. Ramos called his daughter to tell her he might not need to move in after all. Lucia's children played in the corner, unaware that their home hung in the balance. As everyone was leaving, my next-door neighbor Mark lingered behind. You know he's going to retaliate, right? Gordon doesn't handle losing well. I nodded. That's why I'm documenting everything. Every email, every illegal entry, every threat. If he retaliates, he'll just be digging his legal grave deeper. The next morning, I woke to the sound of drilling outside my door. At 6:30 a.m., well before the legally permitted time for construction, workers were noisily tearing up the hallway flooring. I recorded video of the scene, including the timestamp, and filed a noise complaint with the city. Gordon's response came by email an hour later. Emergency hallway repairs necessitated an early start. This is not targeted at any specific tenant. Carmen added this to our growing file and proceeded with filing the emergency injunction. By that afternoon, we had a court date scheduled for the following week. Gordon's next move was both predictable and short-sighted. A formal letter appeared under all our doors. Due to increasing maintenance costs, a special assessment fee of $500 per unit will be due with next month's rent. He can't do that, Carmen confirmed after I forwarded her the letter. Special assessments aren't permitted under your lease terms or local ordinances without proper documentation and advance notice. This is textbook retaliation. I gather the other tenants again, this time in our building's small courtyard to avoid giving Gordon any ammunition about unauthorized gatherings. Carmen joined us with news. The city inspector's office has no record of any renovation permits for this building, she told us. Not only that, but they're very interested in the unpermitted work that started in the hallway this morning. I've added all of this to our filing. Lucia looked worried. Can we really win against him? He has more money, more resources. But we have the law on our side, I reminded her, and we have evidence of everything. The court hearing for our emergency injunction arrived quickly. Gordon showed up with 2 attorneys, looking confident in an expensive suit. His expression faltered slightly when he saw 9 tenants enter with Carmen, each carrying folders of evidence. The judge reviewed our documentation methodically. Gordon's contradictory communications, the online listing proving no major renovations were planned, the illegal entry, the retaliatory noise and special assessment fee, the lack of permits. Your Honor, Gordon's attorney attempted, my client acknowledges some communication errors, but maintains that the building requires essential renovations, which is why he advertised the units as available with no major renovations planned, the judge asked pointedly. Holding up our evidence, Gordon leaned forward to whisper something to his attorney, who looked increasingly uncomfortable. The judge continued reviewing our documentation: the targeted evictions of only rent-controlled units, the pattern of harassment, the attempted illegal entries. Mr. Mercer, the judge addressed Gordon directly, these documents suggest a pattern of bad faith eviction attempts targeting specifically rent-controlled units. Do you have renovation permits filed with the city? Gordon shifted in his seat. We were waiting until the units were vacant to finalize the renovation plans and permits. So you issued eviction notices for renovations before determining what renovations were needed or obtaining permits? The judge raised an eyebrow. Gordon's attorney tried to intervene, but the damage was done. The court finds sufficient evidence to grant an emergency injunction against all eviction proceedings for this property, the judge announced. Furthermore, the court orders the landlord to cease all harassment activities, including unscheduled entries, early morning construction, and retaliatory fees. A full hearing on the class action complaint will be scheduled. Outside the courthouse, Gordon caught up to me as I was talking with the other tenants. You think you've won, but you've just made things worse for everyone, he hissed. I'll find legal ways to make all of you leave eventually. I smiled calmly, my phone recording in my pocket. Every threat you make just strengthens our case, Gordon. Maybe it's time to consider selling the building to someone who actually wants to be a landlord. His face reddened. You have no idea what that building is worth. I could sell it tomorrow for millions. Not with a class action lawsuit pending and an injunction against evictions, you couldn't, I replied. Your property value drops every time you threaten your tenants. Gordon stormed off toward his expensive car, already on his phone with what I assumed was one of his attorneys. The next few weeks brought a series of increasingly desperate moves from Gordon. He tried claiming the building had plumbing issues that required vacant units. He remembered urgent electrical work that couldn't be delayed. He even suggested asbestos had been found in the walls, claims quickly disproven when Carmen requested documentation and testing reports. He's getting reckless, Carmen observed during our weekly tenant meeting. Every false claim he makes gets added to our case file. His own attorneys seem to be struggling to control him. Gordon's property manager quit after being named in our lawsuit, unwilling to risk her professional license by participating in illegal eviction schemes. The replacement manager lasted only 2 weeks before also resigning. He's running out of people willing to do his dirty work, Mr. Ramos noted with satisfaction. Our case attracted local media attention. Tenants stand up to bad faith evictions, read the headline in the neighborhood paper. Housing advocates reached out to offer support. Local politicians, sensing a winning issue, began talking about strengthening tenant protections. Gordon's family started reaching out, their tone markedly different from his threats. My brother isn't handling this well, his sister Miranda admitted when she approached me outside the building. The property was our father's, and Gordon feels entitled to maximize its value however he can. By breaking the law and violating our rights? I asked. She sighed. He's always been like this, thinking the rules don't apply to him because he has money. But this lawsuit is affecting more than just the building. His reputation in real estate circles is suffering. I maintained my distance. Their family drama wasn't my problem. My focus remained on protecting our homes and holding Gordon accountable. The final hearing painted a very different picture from Gordon's imagined triumph. Gone was his cocky attitude, replaced by barely concealed panic. His legal team had grown to 3 attorneys, all looking increasingly concerned as the judge reviewed the mounting evidence against their client. Your Honor, Gordon's lead attorney attempted, despite these communication missteps, my client had legitimate business interests in renovating the property. Legitimate business interests don't override tenant protections, the judge replied. And the evidence suggests these weren't missteps, but a coordinated effort to remove rent-controlled tenants through false claims. The judgment, when it came, exceeded even Carmen's expectations. The court ordered a 5-year prohibition on evictions for current tenants, except for specific, legally valid reasons, with court oversight required for any eviction attempt. Gordon would pay substantial damages to each tenant, enough for many to save for down payments on their own homes if they chose to leave voluntarily. Most significantly, the court appointed an independent property manager to oversee the building operations, effectively removing Gordon from day-to-day management decisions. You've destroyed my property's value, Gordon accused as we left the courthouse. No, Gordon, you destroyed it yourself. I just made sure you couldn't destroy our homes in the process. His sister Miranda was waiting outside, not to support Gordon, but to talk to me. The family is forcing him to sell his stake in the property, she revealed. This lawsuit has affected other family holdings. Investors are backing away from partnerships with him. I'm sorry for your family's situation, I said, meaning it, but we just wanted to keep our homes. I know, she replied. That's why we're exploring selling the building to a nonprofit housing trust. It would maintain the affordable units and remove Gordon from the equation entirely. 6 months after our court victory, the building transfer to a community housing trust was finalized. Gordon's family had cut their losses, selling the property at below market value to end the ongoing legal battles and public relations nightmare. My tiny apartment remained my home, now with proper maintenance and the security of knowing it would remain affordable housing for future tenants as well. The elderly residents no longer feared being forced out of the neighborhood they'd lived in for decades. Lucia's children could stay in the same school with their friends. Carmen invited me to speak at tenant rights workshops, sharing our story as a successful case study in fighting back against illegal evictions. The critical factor was documentation, I told nervous tenants at one session. Every email, every contradictory statement, every illegal entry, it all created a pattern that couldn't be explained away. Gordon had thought his wealth and connections would make him untouchable, that tenants would be too intimidated or resource-strapped to fight back. He'd underestimated the power of organized tenants who knew their rights. 1 year after our court victory, I received an unexpected email from Gordon. I lost everything because of you, my reputation, my family's trust, my future in real estate. I forwarded it to Carmen without responding. His ongoing bitterness only validated our fight. Through the grapevine, I heard Gordon had moved to another state, trying to rebuild his real estate career where his reputation hadn't preceded him. His sister Miranda had become an unexpected ally in affordable housing advocacy, serving on the board of the very trust that now owned our building. He still doesn't understand what he did wrong, she told me during a building community meeting. He sees himself as the victim of unfair housing laws, not as someone who tried to circumvent legal protections. I kept every document from our legal battle organized in a file cabinet, not as a reminder of stress, but as proof that standing up for your rights can work, even against powerful opponents with deep pockets. At the 2-year anniversary celebration of the building's transfer to the Housing Trust, I stood addressing my fellow tenants and housing advocates. The building had been transformed, not with luxury upgrades to justify rent hikes, but with careful maintenance and energy-efficient improvements that kept it affordable while reducing utility costs. When I received that eviction notice, I had a choice, I told the gathered crowd. I could have panicked and moved, or I could have fought alone. Instead, we built community and fought together. One tenant might be ignored, but a united building cannot be silenced. Mr. Ramos, who still lived across the hall from me, nodded in agreement. His daughter stood beside him, no longer worried about finding space in her small apartment for her father. Lucia's children, now teenagers, helped serve refreshments at the gathering, secure in the home they'd almost lost. The city council member who attended announced new tenant protection legislation inspired by our case. What happened in this building exposed loopholes and enforcement gaps in our housing laws. The Mercer Act we're proposing will ensure landlords cannot use renovation claims as pretext for eliminating affordable housing. I thought about Gordon's initial eviction notice, his casual cruelty, his assumption that tenants would be too intimidated to fight back, how he'd expected us to scatter without question, proving him right about the disposability of regular people when confronted with wealth and power. Instead, we'd built something stronger than before. Each tenant in our building had discovered their voice, their rights, their power to resist unjust treatment. Many had become housing advocates themselves, helping other buildings organize and resist similar tactics. The new property manager, hired by the Housing Trust, approached me with a question about the community garden we'd started in the once-neglected courtyard. As I explained our planting schedule, I caught a glimpse of my reflection in the window. I saw what Gordon had failed to see 2 years ago. Not just a tenant paying below-market rent, but a community member, an educator, someone willing to fight not just for herself, but for everyone who called this building home. His eviction notice had meant to be an ending. Instead, it had been a beginning. not just for me, but for every tenant who heard our story and realized they deserved secure housing, protected by laws that even wealthy landlords couldn't ignore. Sometimes the most powerful weapon against injustice is simply knowing your rights and finding the courage to stand together and defend them. Gordon had owned the building, but he'd never understood that a building isn't just property, it's people's homes, their security, their community. In trying to maximize his profit, he'd lost sight of the human cost and ultimately lost everything else as well. My tiny apartment still has the worn hardwood floors and the window seat where I grade papers. But now it also has something it never had before, true security. Not just for me, but for anyone who will live here in the future. And that victory is worth more than any amount of real estate profit Gordon might have made. The power of community. What began as one tenant's resistance had blossomed into something much greater. In the months following our victory, tenant rights organizations across the city began reaching out, asking us to share our strategies. Carmen, now recognized as one of the city's foremost tenant rights attorneys, had taken on 3 similar cases, using our documentation approach as a template. The Mercer Building case, as it came to be known in legal circles, was being taught in law school housing clinics as an example of successful collective action against predatory landlord practices. What made our case particularly powerful wasn't just that we'd won, it was how comprehensively Gordon had lost. 2 other buildings in our neighborhood with similar issues reached out, and we helped them form tenant associations. One group successfully negotiated better terms with their management company. The other was in the process of forming a tenant-owned cooperative to purchase their building. Lucia, once hesitant to fight back, had found her voice through our struggle. She now worked part-time for a housing rights nonprofit, helping immigrant families understand their legal protections. Mr. Ramos had become a beloved figure at tenant meetings, sharing his story with quiet dignity that commanded respect. Meanwhile, I'd been approached by a publisher interested in a book about our experience, a practical guide for tenants facing similar situations. The advance wasn't much, but it would help fund a scholarship I'd started for community college students facing housing insecurity. Gordon's sister, Miranda, called me on the 3rd anniversary of our court victory. "I thought you might want to know," she said, her voice oddly sympathetic. "Gordon filed for bankruptcy last month." I wasn't sure how to respond. I hadn't wished financial ruin on him, just accountability for his actions. "The family tried to help him," she continued, "but he refused to acknowledge any wrongdoing. He kept making the same mistakes with other properties, thinking he could bully his way through tenant protections." "I'm sorry it came to that," I said, and meant it. "Don't be. Sometimes people need to hit bottom before they can change. And honestly, what happened with your building was the best thing for the tenants and probably for our family in the long run. We're much more careful about ethical property management now." After we hung up, I sat in my window seat, watching the community garden where my neighbors were planting spring vegetables. What had started as a desperate fight to keep my home had transformed not just our building, but had rippled outward, changing lives, policies, and perhaps even the culture of real estate in our city. That evening, as I graded papers in the same spot where I'd received Gordon's eviction notice years before, I reflected on how quickly rights can be threatened and how powerful ordinary people can be when they stand together, armed with knowledge and determination. Gordon had seen us as obstacles to his wealth. He'd never understood that we were human beings with rights, dignity, and the courage to defend our homes. My worn hardwood floors had seen it all. The fear, the meetings, the solidarity, the victory. They would remain, carrying the history of our fight long after all of us had moved on, a silent testament to what happens when tenants unite. The Mercer Act passed the following year, strengthening protection for rent-controlled units citywide. At the signing ceremony, the mayor invited several of us to stand behind her as she put pen to paper. The photograph appeared in the local paper. Lucia, with her now college-age son, Mr. Ramos, leaning lightly on his cane, Carmen looking professionally satisfied, and me still somewhat amazed that our small resistance had grown into lasting change. Gordon's eviction notice had backfired spectacularly. In trying to displace us, he had instead secured our homes for generations to come and written himself into housing rights history as a cautionary tale of landlord overreach. The building he had seen merely as an underperforming asset was now a model of stable, affordable housing. proof that profit motive without ethics eventually consumes itself. My tiny apartment, with its history of struggle and triumph, feels more like home than ever. Each time I help a new tenant understand their rights or speak at a housing workshop, I remember the lesson Gordon never learned. A building is not just property, it's people's homes, their security, their community. And when those people stand together, they cannot be moved, no matter how powerful the forces against them.